Thank you. In the world of freelancing, the entrepreneur has to take on a number of tasks for themselves that would normally be handled by a separate department at a bigger company. Most of these tasks are not part of the creative processes that freelance editors are used to, but rather more tedious paperwork. One such task is contracts. And our guest this evening will remove a lot of the headache and guesswork that comes with drafting a contract. Cynthia Cosentino is an associate lawyer in the real estate division at Tibollo and Associates Professional Corporation, where she has practiced law for nearly 6 years. Cynthia has acted on behalf of a wide range of clients, from small businesses and privately held corporations to large financial institutions. She has developed a wealth of knowledge in drafting and negotiating an array of documents for complex transactions. Please welcome Cynthia Cosentino. Let me know if the sound is okay. Thank you, Andrea. Thank you to the organization, and of course to all of you for being here this evening. It's my pleasure to be here and to speak before you this evening. Yes, as Andrea mentioned, the bulk of my practice is real estate, but it ranges on a daily basis from picking up a real estate file to half an hour later working on a share transaction, to drafting wills and dealing with estate matters. So I do get a good variety as far as my practice area. It is a full service firm, and one of the benefits of working in a small collegial office is that you've got the benefit of bouncing from one lawyer to another, where we've got a litigation department, a corporate commercial department, because you never know what areas you're going to be touching on with respect to that particular file. And even though it may seem as though, well, it's standard real estate deals, I can assure you with every transaction, you never know what you're going to get. Every file is unique, every client is unique, and so anyhow, I'm here to discuss some points that I think hopefully you'll take some useful information from. Of course, it's not legal advice, it is more for educational purposes, but also to get you thinking about things that could benefit you, in particular with the contract realm of things, and try to, of course, avoid some liability issues, which, in speaking with Andrea, I know that was some of the concerns or the queries that were put forward in terms of how to avoid those types of scenarios. So hopefully you'll glean some useful info from this. Of course, after the presentation is done, feel free to speak with me if you have any further questions. So I'm going to basically go through some basics of contract law. I had to sort of think back to what did my first year law professor teach us, even though we use it on a daily basis, to make it simplified and again, to make it useful for all of you in your industries. So I do know that there is a form of freelance agreement, which I did have a chance to look at. So it's to build upon that, and whether or not you use that agreement or not, of course, it's to take some useful info in your particular situation. So starting from the very beginning, it's important to know who you're dealing with. Who's your client? A lot of you, from what I understand, are freelancers, so you've got clients who are retaining your services to do editing for publications or whatever pieces that they've written. But it's a good idea, especially in today's day and age where everything is so accessible online, even to try to know, do a quick search, maybe even came through referral. Who are you dealing with as far as the type of pieces they write, type of reputation? Are they known for having litigation issues? I mean, nowadays, even with court cases, a lot of stuff is available online. So just in terms of knowing who you're dealing with to try to avoid putting yourself into precarious situations down the road, that's always a helpful thing to know who you're dealing with. But in putting your contract together, now whether you're using the standard form or some other form of agreement, it's important to make certain that your terms of your agreement are clear as far as the services that you're providing. What are you providing and what aren't you providing? It's important to have those clearly laid out even for your own well-being, so that you know exactly what your services are, and also to protect yourself so that you're not being expected to do other things which you're not being employed to do. You're subcontracted, but you're not being paid to do. So it's important to have those parameters clearly laid out. It avoids, I ambiguity. And often in contracts that I will draft, depending on the situation, I'll even put, for clarity purposes, it does not include A, B, or C, depending on the situation. But I like to make it as plain in English as possible, not even using fancy legalese, so that way there's no misunderstanding as far as the parties are concerned. What is it that we're talking about here in terms of the services? Which then leads to the next point, avoiding the ambiguity issue. So the terms of the contract need to be certain. If there's a provision in the contract which is vague, there's actually a fancy Latin term for it, but in plain English, it's basically, if there's a provision that isn't clear, it goes basically against the drafter. So you want to make sure that there's no issues with that, because if there is a dispute down the road and I've drafted that provision and it wasn't clear, well, guess what, that works against me. So we want to make sure that it's clear as far as what's being done, and not even just the services, but any other terms that you have in the contract. Let's make it clear for everybody to understand. As far as when I'm drafting the contract, if there's something that's a little bit unstandard, or a little bit contentious at the point of when we're negotiating a deal, I'll often pop into our litigator's office and say, hey, if this thing doesn't go well down the road and this is put before you, where would we stand if you've got to argue this in court? So that's the benefit also of having that side to it, because you want to avoid those issues. And unfortunately, when you're drafting, you're always thinking worst case scenario in your mind. If this goes before a judge, what are my chances? And of course, in litigation, there's never a clear-cut winner, but there's always who's got the better case or the better claim to make. So you want to try to avoid those situations. And again, avoiding ambiguity and vagueness is one way of protecting yourself. It's also again, sometimes we have discussions and friendly relationships, and there's verbal portions. It's not that there can't be a verbal contract, but it's in your best interest to have the terms of the contract in writing. And if, let's say, there's an amendment to it or an addition to it after you've already signed your agreement, it's best to have it as an addendum to the contract, so that at least you've got that in writing. I can't tell you how many times, whether it's real estate files or commercial transactions, you find out after the fact that everything's all signed up. Oh, but so-and-so said that after closing I could have this, or that I could live in that house, or whatever terms. I don't know anything about this. Had I known it, we would have built that into the agreement to at least provide some protection. I really don't have much to go on with the discussion. And then sometimes things go sour and people change their minds, or they conveniently forget things. So it's to your benefit to have everything in writing, and we always have a provision in our contracts that any verbal discussions or negotiations don't form part of the written contract. So it's best to have it in writing, as well as to have the pages initialed by both parties. It helps at least to reinforce that we've had a chance to go through all these provisions, and avoiding any issues of slip sheeting pages into the contract. So it's just, again, good practice to do these types of things for your own protection. Another provision to include in there, which I'm sure you will in your contracts, is the form of payment. In terms of when you get paid, or is there interim billing, where payments get made, those types of details that you should include in your agreement as well. Not to just assume I will get paid this amount. Well, when and how will you get paid those amounts? Also, in the event, I think this was raised as one of the questions that one of your board members may mention in terms of how to terminate an agreement. The contract is a contract, so if there is a certain way that you wish to have the agreement terminated, and I did see in the freelance form there that I mentioned in the event of a material change. That's great. It's good to define what would constitute a material change that would then trigger the termination of the contract. So again, we need to have certainty in terms, no vagueness. What may be a material change to me may not be a material change to you. So let's have that laid out in the contract, in addition to whatever other terms that need to be spelled out. So that's an important one there, especially if you're trying to ensure that if there is such a material change, you're able to terminate the contract. And also in terms of the payment, what gets paid up into the termination date. If there's a defaulting party, typically that party isn't rewarded. But again, these are terms that you and the other party would be negotiating. Let's just make sure that it's put into the agreement and that it's clear so that both sides know this is the arrangement that we've made, and it's put into writing. We've initialed it. We all agree this is what will happen in the event. Again, we always have to think worst case scenario, because unfortunately things do happen. That's what keeps litigation lawyers employed, and they keep going. So there's definitely no shortage or shortfall of litigation, and I always tell clients, you want to be dealing with me. If I got to send you off to my colleagues in litigation, then it's there's some trouble, because that's when things have taken a negative step. So at our stage, we try to get you, again, every contract can be contested. It's how good of a case you've got in terms of how the provisions are drafted so that it's clear. And obviously, if someone isn't complying with the contract, they're in breach. I can't do anything to stop somebody from complying with it. But as far as you're concerned, and trying to protect yourselves, again, we want to be clear and certain of the terms. In the event that, and I'm not sure how many, if there are any here, but in the event you're the one retaining the services of a freelancer, just one quick liner on that, it's also a good idea to have a confidentiality provision in your agreement. That's important, especially depending on the nature of the work that's being edited. I did see in that freelance draft agreement, there is an indemnity provision. It is a good idea to have that built in there, so if that party does something, and this ties into the how do I avoid getting sued and how do I try to prevent those types of scenarios, it's best to have some sort of an indemnity. The legislation does say it's not unlawful to have such a provision in the agreement. Again, just basic terms. In the event that someone does something inappropriate and you're somehow dragged into it, but you're pulled into the litigation, and it's got nothing to do with your work, because again, we've spelled out what your parameters are as far as the services you're providing. Then at least you can have the other party indemnify you in the event of such a claim. So one way of trying to, again, protect yourself from those types of situations. And why do you want to do that? Because legal costs are very expensive. Litigation is not a cheap thing, and apart from the stresses it puts on people, because nobody likes to be sued or suing someone else, it's never a quick process, and it is quite expensive. So we want to try to avoid those types of scenarios. Don't tell my colleague that. She's probably very upset that I'm talking about that, but I'm just teasing. And another point too on that is a lot of times, and again, regardless of the situation or the size of the transaction, a lot of times clients think, I don't need to have a professional review this. I don't want to spend the extra money. It's a short-term agreement anyhow, but the extra few dollars that it would cost you to have a lawyer to review it could save you in the long run, as far as presenting different ideas that you didn't think of in terms of what other provisions to add into the agreement. Or again, if you're filling out the form yourself, again, our writing styles, we're trained to do things differently. I'm probably be terrible at doing what you do, but there's a reason, because I'm trained to write in a different manner. So again, not that I'm plugging the profession, but I do see it far too many times where things could have been avoided had we had the opportunity to address those provisions before the agreement gets signed and finalized, and everybody's going off and doing their thing, and then there's an issue after the fact. So one thing to consider is insurance. I don't know how many freelancers have insurance, but I can tell you, in speaking with their litigation lawyer, defamation lawsuits are not cheap. She's seen the standard is $1 million as far as the claims. They're very expensive, but that's something we don't want to have. Lawyers have insurance. We get sued all the time. I don't know in terms of the types of coverage that you could get, but it is a wise idea at least to look into that if you're not already getting coverage from an employer. It is something to look into because there is that potential exposure. So we want to look into minimizing exposure for sure. So something to look into. I don't work in the insurance industry, but like I said, it was something that in speaking with litigation counsel that she said it's something you guys should look into as far as getting some added protection. And segueing into a little bit about the defamation, because I know that was something else which ties into as far as how to avoid those types of issues. Depending on the medium, especially with internet, you see how quickly information gets disseminated. It's faster than blinking your eyes, how quickly things can spread. But it's also because of that award damages can tend to be greater because of how quickly the information gets spread. And I do have a case, but I don't know how technical you want me to be as far as that, but that's just something to keep in mind as far as any work you may do that is internet-based. And even, I'm going to just assume, go back to basic terms. As far as defamation, it's the unjust harming of another's reputation by libel or slander. Libel is defamation in a fixed medium, so print, newspaper, written story, a cartoon, a videotape, and slander is oral. So just to have those terms, sometimes we use them interchangeably, but one means one and the other means another. So I won't bore you with too much on that, but one thing that I wanted to bring to your attention that I thought would be useful is there are various defenses available to people who are accused of defamation, one of which is it's the truth, but another one is it's a fair comment, there was a lack of malice, and one which is more relevant to you all is responsible journalism, which is a defense as well. So there actually is a case that it's an Ontario Court of Appeal case from 2007, and for this defense to succeed, a journalist or media defendant, that's in quotes, must show that reasonable steps were taken to ensure the fairness and veracity of the published content. And it's like the fair comment defense, the information must be of public interest. So what are considered reasonable steps? Of course, it varies with the circumstance. They're never going to have a cookie cutter mold for each scenario. It's going to, every case needs to be weighed on its own circumstances. There were 10 factors which were adopted by the higher court in the UK as far as steps to ensure whether reasonable steps were taken. However, the list is not exhaustive, and something of interest to you all is that the decision to admit the defense by the Ontario Court of Appeal is presently on appeal to the Supreme Court. So this should be an interesting decision when it is rendered. And one thing, not to scare you all, because I didn't want to end your last speaker's series on a sour note, but sort of what we want to make sure that you're thinking these things so that you can prevent these types of scenarios. Someone can, again, whether or not they succeed or not, but a claimant can take action against any or all of those involved in the process of a publication. So it could include the author, the editor responsible for the content of the book, and the company who publishes it. So again, that indemnity clause is helpful. Again, it doesn't say that you would be named in some sort of a suit, but as far as having a defense against it is what you want to do. And that's why it's important to try to, again, do your homework as far as who you're dealing with, to try to avoid situations where you may be dealing with somebody who may have issues complying with the contract. We don't want that, and then in terms of also the type of writing that they do. So we want to, again, have you doing your jobs and not worrying about these types of things, and the way to do that is to try to incorporate these steps into your contract so that you know what is expected of you, as does the other party, and once it's done, you get paid and you move on. So that's in summary of the info I wanted to give you today. I don't know if anyone has any questions or comments. Yeah.
How long should we be retaining the contract information, and can you scan it and retain it in PDF form, so your house isn't pounding in boxes of paper?
As far as the work that you've completed for the client?
Yeah, well, let's say the work is completed and you have the contract, well, in terms of indemnification, that's stuff that you could need quite a while after. How long do you retain those documents for? And is it acceptable to turn it into a digital scanned format so that you don't have boxes?
Yeah, I mean, typically the legislation is there's a 2-year limitation period. So as far as I know, that's in terms of scanning it, there shouldn't be an issue unless the contract prohibits you from keeping those works. But typically, you've worked on those files and would have certain rights to keep them, and it's advisable to keep them, even though there's.
I was thinking just of the contract.
Just yeah. Yeah, no, the actual contract, there's no issue with you keeping it for at least the 2 years. There's no harm in keeping it longer, just because, and also even as a precedent, if it was something you can perhaps refer to in the future if it's similar type work. But again, just keep in mind every contract, every work that you do is different, so cater it to that particular situation, although there may be provisions you can draw from.
Is an email acknowledgement of the contract terms sufficient, or is it required to have an actual signature?
I mean, it's preferable to have an actual signature, only because, like I said, there's typically at least a signature line that this was accepted by all parties, the date. You can have a counterparts provision. You can have a provision in there that says you'll accept facsimile or email transmissions as an original. Because I understand in this day and age, it facilitates things, but it is best to have it signed. Again, I would suggest even having the pages initialed, but if you have a provision like that in there, then at least you can say if this agreement can be signed in counterparts, but together it forms the one agreement. And that way at least you've got a properly signed contract, and we do that fairly often as well, just because you're dealing with firms sometimes that are hours away from you, and to make things expedient, but you can definitely do that. Yeah.
I think my question kind of takes off from the previous question. Now, what happens, I mean, you were talking about, making amendments after signing, or even verbal contracts. Now, what happens, I mean, people communicate by email a lot, which makes a nice sort of paper trail. Mm-hmm. Now, if you either make a contract, a signed contract, and discuss amendments after the fact by email, is that record as good as an initial change amendment on the contract?
I mean, it gives it more weight if you have an actual amendment that says this amendment refers to the contract between A and B, signed on such and such a date. And again, it doesn't have to be anything formal and fancy. You can just add, the parties agree to add the following to it. And that way, at least it's preferable to have it signed. I don't know, again, in terms of the litigation, whether one has more weight than the other, but I'd rather err on the side of caution and have it refer to that, and both parties acknowledging it by way of signature is a good way to protect yourself. And again, you can have the counterparts, so if it's easier to do it that way, just by email.
Thanks for your suggestions that you're making here. I'm already seeing modifications I have to make.
Good.
One trouble area I got into recently had to do with negotiation of a kill fee.
I'm sorry, I didn't hear what you said.
Negotiation of a kill fee. So the client and I decided we wanted to go our separate ways. Can you make recommendations, like should I have had something in the contract itself, or
Is that a term that I'm not going to kill in terms of just terminating?
Yeah, before
before.
done.
Okay, and that's something that I've seen in the sample agreement in terms of terminating, and as, just to touch on what I said earlier, is it's good to have it, or it's beneficial to have in there what terms would basically kill the deal, what terms of default there would be, and what happens then at that point. So again, we're always anticipate in the event, worst case scenario, what happens, and we typically build into a contract in the event of default, what happens and what constitute default. Again, you want to have it clear as far as what would kill the agreement and the parties go their separate ways and what would happen. So at least if it's laid out in there, and I know if I've done something and then this agreement is at an end, I know what my obligations are, if any, at that point in time. So it is beneficial to have that built in there. Again, it's not a bad idea to have someone look at the language if there's any uncertainty that you may have, but I can't stress enough, it's important to have an actual agreement in place. And contracts don't have to be 50 pages, they can be simple, but as long as the parties understand what is to take place during this 6-month period or however long it may be, at least that gives everybody some more reassurance as far as what's expected of them. Again, not everybody likes to play nice and comply with what they signed up for, but at least you have your remedies in the event that they aren't complying with their end of the bargain that you've both signed on to and you've negotiated and agreed to. You had your hand up before, so I'll go back there.
You said that it's good to put in a contract how and when you will pay. What happens in a situation if, let's say, a month after the payment deadline, the client still hasn't paid and the project isn't finished? What steps can an editor take other than hiring a lawyer? What can you do if someone's not paying to actually have it?
I mean, it is a contract, so they've breached the term of the contract, and unfortunately, it happens. Like I just said, sometimes people don't like to live up to their end of the agreement. Unfortunately, that's the risk we take sometimes in any profession. I mean, you can send a demand letter. You can, without trying to have to go the lawyer route. There is small claims court depending on the amount of it, which is pretty user-friendly because a lot of people who do small claims court actions are self-represented. I mean, I know that that's not ideally what people want to do, is to have to go and sue somebody, but short of sending them a few letters to say, I will proceed if you don't pay me as per contract, you really can't make them do it, and you've got to decide, you've got to outweigh the costs as far as how much is outstanding to you, how much time, do you have to take time off of work, there are certain court costs that you will have to pay if you are doing it yourself. Obviously, you aren't hiring a lawyer to do it, but that's the cost analysis that you'd have to do, and that's what we always tell clients, whether they want to start a litigation process. We tell them, well, this is how much realistically you're going to spend on us, and this is how much the potential is that you could recoup from this. And also, and that's part of going back to step one, is knowing who you're dealing with. How successful will you be even if you do get a judgment in collecting it from that particular person? Do they have a habit of doing those types of things and defaulting, and do they have a whole list of people after them and you're just another person in line trying to collect? So it doesn't hurt to, even if you wanted to have a free consultation with a lawyer, to at least canvass your options, and then from there you can always decide whether or not you want to pursue it or not. And there's paralegal as well that are less expensive than lawyers.
Yeah. Again, from the other question, my father used to run his own business, and if you're going to go the step of small claims court, I'm just wondering, because he had issues where either he or my mother went to small claims court to deal with somebody who didn't pay, a judgment in their favor, and they still didn't get paid. Still didn't pay. And, I mean, I'm sure there are people, and probably the worst kinds of people, who do that. Do you have recourse where you have a judgment and the client still refuses to pay?
There are different measures as far as garnishing wages. If you have a judgment, I see it all the time on the real estate end of things, whenever somebody goes to sell a house or refinance a house. So guess what just popped up on my search? You've got a judgment against you, which that person waited a few years, but they figured one of these days you're gonna have to either refinance or sell that house. So when you do, that's when I'll collect my judgment plus any accrued interest. Unfortunately, it's in those types of scenarios, it's often not a quick recovery, but
Waterford to info desk, please. Waterford to the info desk.
but there are those types of available options. Again, it's not a nice situation. You've lived up to your end of the bargain, and somebody else has not decided to live up to theirs. But those are options that the courts provide.
Okay, and then just finally, since, I mean, this is a lot of work, and especially if somebody's self-represented, they're doing it themselves, or if they have a lawyer, it costs a small fortune.
Right.
Do you have any advice on when to say, when to cut and run and when to pursue?
Again, it's looking at how much you have to invest as far as time and money, and what the actual claim amount is, what your award is as far as the order that you've received, or even if you haven't even reached that stage. It's a costing number. It's how much you're willing to spend as far as time and money on something. And there's a lot of people that are litigious, and it doesn't matter whether they get $1 out of the end of it, they're still going to fight because it's the principle of it. And then you get some that they say, I was wronged and I was owed this money, and it's not fair that I have to walk away from it, but at the end of the day, I'm going to pay you guys twice that amount just to go and fight it, and then potentially recover the money from me. So it's an individual assessment someone has to make. Unfortunately, that's the nature of how it goes, but it's something that each person has to decide whether or not they want to invest in that recovery. Yeah.
The contract that's up on the website, would that work only for in Canada, or would we need something else for an international client? Because I have someone in the US that I deal with, and I have a contract with them, but I actually, now that we're working well together, I'd like to actually have a more official contract.
Yeah. As far as, it does, we do always put a provision in there. This is construed in accordance with the laws of the province of Ontario and Canada, so it's an Ontario contract, depending on where the services are taking place. So that's something you'll have to look at. But as far as, I don't know the situation, but we can chat after and we can give you more details. But you do need to include in there, if it is an Ontario contract, it needs to comply with Ontario law, even if I have clients who are dealing with other jurisdictions or other countries, even as far as drafting wills, that we always tell them to consult with a lawyer in that particular area, because the laws are different there, and we're licensed here in Ontario. So it is something you should put in place, and like I said, Ontario and Canada. Any other questions? Hopefully I didn't scare you off too much. I try to, again, it's to help you and to keep you thinking next time you're entering into a new working relationship, the types of things that you should be thinking as far as your expectations, and to give you a bit of comfort before pursuing that job. So thank you again for having me. It's been fun. I sit on I'm behind the computer all day, so I don't get to actually speak in front of people all that often. So when I do get the opportunity, it's good for me as well to get out there. So it's nice to interact with people. Okay, well, thank you. Obviously, if there's any other questions that you think of, I'm still going to be sticking around for a while longer. So thank you.
Cynthia mentioned it's scary of us.
Okay.
If anyone has any questions, she will be here this evening. So please stay and join us for coffee, which hasn't arrived yet, but we'll make sure it's here. But on behalf of the Editors Association Canada Toronto branch, we want to thank you for your time and expertise. A donation has been made to the Canadian Children's Book Centre. However, please accept this small token of our appreciation. And thank you very much.
Thank you. It was my pleasure.